the set of topics that are directly and most importantly related to university patent filings. There are some other updates to the law that have to do tangentially with the university, and so we'll go through those a little bit so that we can sort of get an idea of why that can be relevant. One of the new tools that's been implemented with the Act is that there's this procedure called supplemental examination. Essentially what this is it's a tool to cure a defect in a patent, an issued patent, where under current law and under the new law, the inventors always have an obligation to disclose information, whether it's a patent or whether it's a publication, that is relevant to patentability. We have a duty to disclose that to the Patent Office. Well, the reality is that often, sometimes references that should be cited to the Patent Office, sometimes they are missed just because of the timing of when they are discovered, either by an inventor or by an attorney. And so it can be the case that there is some prior art that should have been cited in a patent file but wasn't for whatever reason. This new process allows a patent owner to essentially file these references even after the patent's issued, get them considered by the Patent Office, and then that can cure a potential defect with not having satisfied your duty to disclose this information in the first place. Well, that's probably not going to happen a lot for the universities, but it's just something to be aware of, because one, someone might, who's interested in licensing and technology, may have some information that they have found through their own independent investigation, or they may have just gone through the file wrapper history and then found some references that should have been cited but maybe were omitted. So that may come up as a request. And of course, if the university identifies some references that were inadvertently omitted, then it's always there as a tool. If you think it's important to get these things cited, we can use those. Although, again, it's mostly a tool for companies that are actually going to litigate or sue on a patent. Prior commercial use is another topic which, again, doesn't seem to have any impact on a university at all, but it actually does due to some of the exceptions there. Generally, if you've been practicing some invention commercially, say some secret process, you've been practicing it for commercial benefit, secretly, you're entitled to continue to practice that even though someone may have come along subsequently and got a patent on the process that you've been using. So again, that's not something the university is generally involved in, but what this can impact in the university setting is that, one, if some of this secret activity or secret process that has been practiced, it may be a part of some research technique or protocol that's been used in a laboratory, that something that the lab's been using but not necessarily disclosing or publishing in their papers, the university is free to continue to use that technique or that process in their own research laboratory for non-commercial use. So essentially, if someone eventually patents a process that some researcher has been using in a university lab for years, that professor cannot be shut down from doing more research in that area. Essentially, what that amounts to. Another sort of interesting feature is that this prior commercial use defense is not assertable against a university-owned patent, which is kind of an odd thing to be in this law. I'm not really even sure why it's there, but it does add value to university patents, because even though a university owns a patent, it may license it to some company, which then is a commercial entity, but that commercial entity, even though it may find an infringer, that infringer would be unable to use this prior commercial use defense. So essentially, it's one less thing that an infringer may use to get out of paying a royalty under the patent. So that's potentially an added value feature to a university patent. One of the other things that's expanded under the new law is the ability of a third party to essentially participate in the application process. Normally, when you file a patent application, it's the patent applicant who works back and forth with an examiner in the patent office, and it's really just the two parties working back and forth until the patent office agrees on what it is willing to allow in terms of an issued patent. And someone who may have an interest in that area or know information about that type of technology, they essentially aren't able to participate in that process. They can't tell the patent office that they may know about something, some prior art that would limit the ability to get the patent. That's under the current law. Under the new law, a third party who takes an interest in an existing application and wants to make sure information is considered by the patent office, they have an expanded ability to do that. So if they're monitoring the progression of a certain patent application, they can make sure certain information gets before a patent examiner and will be considered. One of the new things that we have once a patent is granted, this again is similar to some foreign jurisdictions, a third party can actually oppose a patent. So normally once the patent office issues a patent, it's an issued patent, and there's someone who disagrees with it, doesn't have any real opportunity to challenge that unless they happen to be sued, in which case you can defend yourself in court to say, the patent is invalid or we're not infringing the patent, one of those two things. But if you happen to believe the patent is invalid, there's no way to actually challenge that patent without being involved in a court case. But now there is a review process that is available to people, third parties who want to challenge a patent without necessarily being involved in some sort of controversy related to the patent. So again, how does this apply to universities? Both of these procedures are probably not something the university is going to be using. They're just going to be very expensive and time-consuming. But the important thing is to be aware that they're out there. So you may have a patent application that's going along well, and or an issued patent that's been issued, and you may find that some other third-party interest is just wanting to participate or interfere with that. So that risk is out there. It's just something to be aware of that you may have to deal with third parties trying to essentially affect prosecution of the application. This is not really that important. You can't patent a human organism. I don't actually do any work in this area. So I don't think we need to spend a lot of time on it, other than the fact that it's not actually new. If you happen to do any work on this, essentially it's just a law which says the patent office can continue to do what it's been doing for the past 20 or 30 years with these types of bio-type inventions. So again, going back to the very first slide, what are some of the things that we need to plan for? The most important elements to the new patent law, namely the first-to-file system and some of these rules related to ownership, assignment. These all take place in about a year to a year and a half from now. So it's important to plan for how you want to behave in the new patent law as these different provisions come into effect. Well, we need to make sure that we have important communication among all the actors in this invention process, whether it's the inventors, whether it's the university tech transfer people, whether it's the attorneys. We want to make sure that we're all working together and trying to do things in a timely fashion. This is a very serial process in the sense that first the inventors have to do the work and invent it. Then the university needs to evaluate the invention disclosure and decide whether or not to file a patent application, and then the patent attorney needs to prepare and file the patent application. So given the fact that we all have to work in series, if any of us are delaying, then ultimately that can compromise the rights or the ability to get an issued patent. And bottom line, it doesn't matter if someone else files first. It doesn't matter who was to blame for the delay, whether it's one party or whether it's all three sharing some of the blame. Essentially, late is late. If you're the second one to file, you have almost no chance to actually get the patent application. So it's important to be aware that timing is important, and when it's your turn to make a decision, your turn to